Very good. We're recording. Thank you all for today for joining this webinar. It's a joint effort between King's College London and George Washington University Law School. We're going to be talking about the question is, are we moving towards a European economic sovereignty? Practically speaking, we'll be talking about a very important white paper that was issued by the European Commission. I want to, before we turn it over to our host, our chairman, Andrea Biondi from King's College London, I just want to go through some ground issues, some ground rules. First of all the opinions offered are the personal opinions of the participants and shouldn't be attributed to their organizations. I'm going to go through some introductions of the panelists with you. We're going to have presentations and we'll have questions and answers. We will have perhaps a few questions at the beginning, and also we hope to have questions along the way. If you have questions, please put your questions into the chat room, into the chat, as opposed to using any Q&A function. Please use the chat function, and the panelists will be monitoring that chat function during the course of today. Just a quick introduction to our panelists. Professor Andrea Biondi is Professor of European Union Law and Director of the Center of European Law at King's College London. He has a distinguished academic record with visiting positions at leading universities, including Georgetown University, the College of Europe, Bocconi University in Milan, and the University of Rome, La Sapienza. He sits on the Advisory Board of European Public Law, European State Aid Law Quarterly, European Public Procurement and Public-Private Partnership Law Review, and he's the General Editor of European Monographs for Kluwer Law International. From 2015 to 2017, he was a legal advisor on EU law to the Office of the Prime Minister of Italy. He's an academic associate at 39 Essex Chambers in London. Christoph Schasser is the head of the European Commission Task Force on Third Country Subsidies and DG Competition. Of course, that's our focus today. He was previously the deputy head of unit in the Commission's DG Comp, after serving in other distinguished roles within the European Commission. He has degrees from Kiel University and the College of Europe and a PhD from the University of Freiburg in Germany. Dr. Luca Rubini is a competition and trade lawyer with a special interest in the regulation of the state intervention in the economy. He is the author of the first theoretical analysis of the definition of subsidy in the WTO and the European Union. More recently, he has extended his focus from subsidy law and policy to the analysis of the various linkages between energy, trade, and climate change, and to an historical analysis of the regulation of subsidies in the 20th and 21st centuries. At the University of Birmingham's Law School, he's a reader in international economic law and deputy director of the Institute of European Law. Elisabetta Regini is a partner in the antitrust and competition practice in Latham & Watkins, Brussels office. Her practice centers on international and European law with a particular focus on state aid and EU regulation. She routinely advises companies, industry associations, and public authorities on state aid compliance and assists them with European Commission investigations and litigation before the European courts. Prior to joining Latham, Ms. Regini worked at the European Commission for 15 years, initially as a member of its legal service, and most recently for 5 years as a senior member of the cabinet, a former competition commissioner and vice president Joaquin Almunia. Renato Nazzini joined King's College London as professor of law in 2012. Previously, he was professor of competition law and arbitration at the University of Southampton, where he joined from the Office of Fair Trading, then the UK Competition Authority, where he was deputy director of the legal and policy development, and later advised on major areas of enforcement and policy. Professor Nazzini is currently a non-governmental advisor to the International Competition Network, where he has been particularly active on the Unilateral Conduct Working Group and on the Merger Working Group. His research interests are in the areas of competition law, commercial arbitration, and ADR, and his work on competition law is focused extensively on enforcement, remedies, and procedures, very much issues we'll be discussing today. I'm Christopher Eukins. I'm a professor of government procurement law at George Washington University Law School and co-director of the public procurement law program there. Michael Bauscher QC, has a busy practice in public procurement, competition, and commercial law, particularly in disputes concerning major public and public-private projects. He is particularly known for his unique practice in regulated procurement in the United Kingdom, Ireland, elsewhere in the United Union, and beyond. Michael Bauscher has appeared as counsel in many of the major procurement cases over more than a decade. He's active in a range of dispute resolution arrangements and has often been appointed as arbitrator, mediator, and expert. He's a visiting professor at King's College London, where he teaches EU procurement law on the LLM degree course and is director of the distance learning diploma and master's in public procurement law. Michael and I regularly work together and join programs like this one between King's College London and GW, and we teach in each other's classes online. Michael is a member of the Bar Library in Belfast and in Dublin and practices actively in Northern Ireland and the Republic of Ireland, as well as in England and Wales. Last but not least, he'll be joining us in a little bit, Alexander Rose. He's one of the UK's leading public funding lawyers with an international reputation for his expertise in EU state aid law, subsidy control, and grant-funded programs. He's a highly sought-after expert in matters involving public funding. He regularly advises upon state aid law, setting up grant programs, and other high-profile sector initiatives. In advising his clients, Alexander is able to draw upon an exceptional range of experience, including acting as a senior solicitor for numerous national grant programs during his 7 years in the government legal department and working within the European Commission upon state aid legislation. It's a very distinguished panel, and I'm very, very glad you all could join. So with that, I'll turn it over to Professor Biondi for his welcome. Thank you very much.
Well, thank you very much, Chris. So that's a nice picture. Thank you very much. Actually, I have very little to add. It's just to express my thanks to George Washington Law School for their support. And I would say both intellectual and technical. I think best information presentation that we had so far. Pretty impressive. So thank you so much. This is becoming a little bit of a solid partnership between the Center of European Law and GW Law School. And again, we hope that we will continue to keep on organizing further and further events. So once again, Chris, thanks so much for your help. We do actually have a rather packed program. So I think that probably is best to get on. As Chris mentioned, we're going to have all the presentation first, but there will be opportunity to ask questions, to formulate comments, and so on and so forth. My role, I think that probably also Chris and myself, we try to be the enforcers, and we try to ensure that all the speakers stick to their allocated time. So in order, as I say, to have a little bit of time for discussion. So without any further ado, I think that I will simply, once again, thanks Christophe for finding the time. And I will simply give the floor to Christophe for a sort of first to lay down the scene, and then all the other panelists will try to offer some comments on specific aspects of this extremely crucial issue. Christophe, thank you so much. The floor is yours.
Yes, thank you very much, Andrea and Chris, for inviting me to this distinguished panel, and I'm looking forward to the discussion. So I will start off by presenting the main elements of the white paper that the Commission adopted and published in June, and that tries to lay out ideas about how, well, what we call foreign subsidies, so subsidies granted by non-EU governments, how they could be controlled to the extent that have an impact on the European internal market. So if we go to the next slide, please. And the one I think behind, yeah. So what is the, just to, well, explain the rationale of this. There is in the EU, there has been for decades what we call the state aid control, so the control of subsidies granted by EU member states in many different forms. And there's I would say, a sophisticated legal framework to assess these subsidies. But there is no equivalent control of any subsidies granted by non-EU authorities that may impact the internal market. And with increasing trade flows and increasing foreign direct investment into the EU, there has been an increasing concern that such subsidies granted outside Europe actually do impact the European markets. We are in the process of looking more closely into these instances of foreign subsidies that market players have brought to us. And now, that's part of the exercise, and we'll say a word about this a bit later. So the white paper analyzes to what extent this issue of foreign subsidies is not already covered by existing European legislation, pieces of legislation, or by other legal instruments at international level. And our kind of preliminary assessment in the white paper comes to the conclusion that neither the competition rules nor the trade policy nor the public procurement rules that exist in the EU adequately tackle such foreign subsidies and their distortions that they can cause on the EU internal market. So notably, we've looked at, in terms of competition policy, we've looked at the EU state aid policy, as I mentioned, which is in a sort the benchmark for what we're doing. But we've also looked at the merger regulation or the antitrust rules at European level. In terms of trade policy, the unilateral instruments, the trade defense instruments, but as well at the roles, the subsidy policy under the WTO. There, I should mention, of course, there are certain subsidy rules at international level under the WTO and in the GATT, but those rules and the SCM agreement that relate basically only to the trade in goods. So if there are anti-dumping procedures or anti-subsidy procedures related to the claim that subsidized products are physically basically imported into the market, but there are not any rules in the area of service provision, investment, or acquisitions. So that's where we see a legal gap in the framework. So what do we mean when we speak about foreign subsidies? So there is a whole definition in the white paper, and actually that definition is very similar to the definition of subsidies under the WTO and taken from the SCM agreement. But that definition again is very similar to the definition of state aid as we know it in the EU. The reason why we've chosen the international definition is precisely because we're dealing with third countries. So to use a definition that is commonly known and accepted under WTO, we think constitutes a big advantage, as we can rely on a common understanding globally, actually. I would like to mention also and to stress that the kind of instrument that the legal instrument, the possible regulation that may come out next year, does not intend to make any distinction between different third countries, or doesn't target specific sectors, or does not target the ownership of a company. So whether it's a state-owned company or a privately owned company, in principle, that legislation, those rules would apply indiscriminately to any subsidy in any third country sector or ownership, but of course with the condition that there is an impact on the EU internal market. If we move to the next slide. As you may know, the white paper proposes different approaches, different tools. In the white paper, we call them modules to test, to see how to screen such subsidies. Well, the first is a general market screening tool where what we call the responsible or the competent supervisory authority, which could be in this case a national authority at a member state level, or it could be at European level, the Commission, can scrutinize in an ex officio procedure subsidies that come, foreign subsidies that come to its attention and which seem to have an impact on the EU internal market. The second module is more focused. It's specifically for foreign subsidies that facilitate acquisition of EU target companies. The difference here is not only that it's more specific for acquisitions, but here the proposal in the white paper is that there would be an ex ante notification procedure for acquisitions that would be financed at least partially by financial contributions from public authorities outside the EU. The third module is again a specific one related to public procurement procedures in the EU, where the proposal in the white paper is again have a certain ex ante notification mechanism. But the precise scope of it obviously would still need to be determined. And finally, just for the sake of completeness, even if I don't think we will enter into that discussion today, is the idea to see about access to the European funds available if foreign subsidies give an advantage to certain companies. to bid for EU funding, so that they would not only have the advantage of having the subsidy from their home governments or from foreign countries, but also that would actually facilitate their access to funding by EU agencies. So if we move to the next slide and go a bit more into detail about Module 1, as I said, the idea is that would be the general tool. Here it would be an ex officio procedure that the authorities would start at their own motion. Like in other competition instruments, there would be a first preliminary review period of the subsidy, and if the existence of the subsidy is confirmed and its impact on the internal market, there would be this would be followed by an in-depth investigation. Well, the assessment criteria proposed in the white paper are linked to the type of subsidy, first of all. So the white paper defines certain categories of subsidies that would be most likely to be considered distortive. So there would be a sort of negative presumption about these subsidies. And the examples in the white paper and taken here come basically from either the state aid world, where these categories of subsidies have, well, generally be found to be distortive, or they come also from international rules where, for example, export subsidies are in generally not permitted except for very limited circumstances. But even if a foreign subsidy doesn't fall into any of these categories, there would be the possibility for the supervisory authority to assess the subsidy based on a number of indicators. Here, just to mention, we would need to look into the type of subsidy. Is it more operating subsidy or investment subsidy, the type of beneficiary, and the market concern. So there's a list of tentative criteria how that subsidy could be assessed in the particular case. The white paper also proposes a EU interest test. So that idea is broadly taken again from the European state aid rules, where there is also an element to see if a subsidy granted by EU government actually complies with what we call a common EU interest objective. And here the idea would be, again, if the negative effect of a subsidy is compensated for by the fact that it actually serves a specific policy objective. And again, there is a tentative list of such objectives, policy objectives, in the white paper. If then on balance still the subsidy is found to be too distortive and not in line with any EU objective, the white paper proposes to impose certain redressive measures. That could be a payment, but there's a list of structural and behavioral remedies depending on the case at hand, on the situation at hand, that could serve to solve the distortive problem. Here, I think, as I said before, the idea in the white paper is, or the preferred solution is, that such an instrument like Module 1 would be a shared competence between the Commission and the member states. That's similar to how the state aid, the distribution of competences is currently in antitrust at European level, where both the Commission and the member states actually have a role to play. If we move to the next slide and to the next module, this is just a bit more detail about the specific module about the acquisitions. As I said, it would be an ex ante notification procedure, again with a two-step process. Here, the white paper, discusses and proposes a number of concepts and definitions that would have to be specified if that instrument came into force, because we would have to define acquisition, if it's just about control, or would this notification requirement be triggered already if a certain share of voting rights or shares were taken over by an investment. Also, we would need to define which EU target companies we're talking about. Clearly, it would be a company that is established in the EU, but to not overburden the process and to limit the administrative burden, the idea is to have rather high thresholds in terms of turnover of the target, but potentially also qualitative criteria. But even if an acquisition were not to fall under this second module, because it's a smaller one, in principle, we think module 1 could serve as a safety net to ex officio look into an acquisition that, even though small, may be really distortive because of a high foreign subsidy involved, for example. So like in module 1, there is a menu of redressive measures. Here, as we're talking about acquisitions, obviously kind of prohibition of an acquisition may be a more prominent remedy, at least as a last resort, if the acquisition is found to be very distortive and the subsidy basically is very prominent in the acquisition process. A bit in contrast to what is proposed for the module 1 here, the idea, the preferred solution at least, is to have only the control and the authority to supervise at European level to ensure a one-stop shop and a quick handling, as we're talking here about acquisitions and like in mergers. Often time is of the essence, and the idea would certainly not be to hold up mergers involving third country operators or operators that receive financial contributions from outside unnecessarily. If we move to module 3, that's about the public procurement. Here, the idea would be that a tenderer that has received a financial contribution would need to indicate this to the contracting authority, so the one managing actually the public tender. That probably, as these contractual contracting authorities may be quite small at local level, for example, probably that information would need to be passed on to a higher level competent supervisory authority, which then assesses to what extent there is a foreign subsidy involved, and that can be considered distortive. And if this is the case, the information would go back to the so-called contracting authorities that would take this into account in assessing the public procurement, where obviously a number of criteria apply, and not just it's only one of many criteria where the foreign subsidy is involved, as you will know, because there are several criteria that are relevant to assess a winning bid in a public procurement procedure. Here, to limit again the administrative burden, the idea would be not to hold up their public procurement procedure, but only in case a winning bid has received a financial contribution that would have to be scrutinized. And if in any event the winning bid doesn't win the winning bid doesn't receive any financial contribution, the procedure could go ahead. Just in line with the public procurement area, the idea would be that, if a distortive foreign subsidy is found to be in a winning bid, that bidder could not actually conclude the public procurement contract. If we move on to the next slide, please. There was this white paper that I mentioned, which is the basis here for the whole presentation and for the basis of the current thinking of the Commission in this area. It was published and adopted in June. There was about 3-month consultation. We've received 150 submissions from all sorts of stakeholders, a lot from industry, but also EU member states, but also from stakeholders in third countries. Well, especially those within the EU were largely in favor of designing an instrument, and where they agreed with the analysis that there is a legal gap, and they agreed that there is actually a need to take legislative action. I think it's fair to say the support was larger for modules 1 and 2 than for 3, as the whole public procurement area is more complex and involves more types of authorities. So there, it's with a caveat with respect to module 3. There were, of course, a number of concerns with those ideas. Very prominent the concern that especially Module 2 and also 3 with ex-ante notification procedures risk creating a lot of administrative burden, so that any instrument would need to be really focused to not create a red tape for transactions and subsidies that are not distortive. Then there were a lot of comments about the concepts and the definitions and criteria that are proposed in the white paper, which to some extent are borrowed from state aid or from trade law, but some of them are new, and also the interplay, obviously, of the different concepts needs to be clarified. So there is a strong request for, if any legislation comes out of this, to really create legal certainty. And finally, a point I want to mention is that, of course, a lot of concern and questions about the interplay of this potential legislation with existing legislation in the competition and trade area, but also with the Europe's international obligations under the WTO or in other multilateral or bilateral agreements. I think I'm almost at the end, but there's one more slide. Yeah, so as I said at the beginning, we are carrying out an impact assessment at the moment to really collect information and to determine more specifically what is needed, if anything. And there is a tentative plan to issue legislation if that is confirmed in the first half of next year. And I think that's all from my side for the moment. Thank you.
Thank you very much, Christoph. I mean, it's not an easy task because, you know, the white paper touches upon so many issues, and thank you so much. You've been really good at keeping the time and also to give us a really good picture of what is going on. Perhaps in the interest of transparency, we should add that Chris, Michael, Luca, Gabriele Carovani, and myself also participating into this exercise of submitting evidence, but you know, it's all online, so transparent, and we're going to discuss some of the points we raised today. Obviously, you know, Christoph is getting a little bit used to be sent first, you know, in order to explain the Commission position, and now he's getting the, you know, all the possible comments and queries and so on and so forth. So once again, thank you so much, and we simply now move, as I said before, to the other speakers, which are going to try to focus on some of the specific issues that Christoph has just discussed. So it's my pleasure just to give the floor or the platform, I don't know how to say, to Luca. I will simply add that Luca has recently his book on subsidy translated in Chinese. So perhaps maybe he's depository of certain further information. I don't know, whatever. Anyway, Luca, the floor is yours, and he's going to look at from the perspective of WTO law. Luca.
Thank you very much, Andrea. Thank you very much to the organizers. I have this presentation. The main topic is really to provide few general comments on Module 1. Christoph has already been very exhaustive on that, and other speakers will deal with that. And then to move without delay to the WTO angle, and in particular to consider two issues. One is the issue of non-discrimination, because clearly if the stated goal of the white paper and Module 1 within it is to reinstate the level playing field vis-a-vis foreign subsidies, at the same time, foreign subsidies should be treated equally, comparably to internal EU state aid. So that will be the first, if you wish, international trade law angle or the of inquiry. The second one will be a jurisdictional, big jurisdictional, even constitutional question, i.e. whether WTO law on subsidy does somewhat preempt any type of action on the part of the EU, and for what matters, any other member states, including the UK, in this specific field. I will close up with a few comments, more of a political nature, on the unilateral nature of the proposed regulation and action of the EU, and on the political scenario, whether anything has changed since this exercise was started and the white paper was published in June this year, and the consultation took place. Change slide, please. So these are my very general comments, and I would summarize all of them in one point, which was anticipated already by Christoph, comes out from the various responses in the public consultation. There are various degrees of clarity, of conceptual clarity on key concepts. For example, on the distortions, so the nature, the type of distortions that the white paper and module 1 want to tackle, and also on the harm that this distortion would allegedly cause, and on the assessment of this harm. So here, for example, if you look at module 1, you have a list of cases which are considered to be particularly distortive, and hence they will normally be prohibited. Nothing new, things that you already find in WTO law, PTAs of the EU, or internal EU state aid law. And then you have, I would say, the general category of cases where you need to carry out a case-by-case assessment. But what you find here is a list of, simply a list of indicators, such as the size of the subsidy, and you don't really find a methodology. So the Commission is telling us we are going to consider these ingredients in order to make up this pie, but we are not giving you the recipe, the procedure. So I think this is an important point that should be clarified in any final document, because here we are talking about action against members outside of the EU. So there is a need, in my view, for an extra degree of transparency and clarity. Another example where you still have a lack of clarity here is where you're dealing with the important EU interest clause, which was hinted at already by Christoph. It is a very important clause because basically it is recognizing that subsidies can also be good. They can also pursue important public policy objectives. And the key message there is that we are going to do a balancing, and if the positive aspects are more important than the negative aspects, we are going basically to give the green light to the foreign subsidy. As you will see in a minute, what is not clear, it again is what goes into this type of assessment. And again, it is an important question if you want to ensure equal treatment of foreign subsidies vis-a-vis internal EU stated law. Next slide, please. So now we focus on the first big point. If you start to look at module 1 and the white paper from the international angle, from the international law, the WTO angle. As I said already, this is really a mantra. The whole motivation of the white paper and module 1, the general module, is really to level the playing field. In essence, EU companies, EU member states are subject already to a very significant form of internal subsidy control, and foreign companies and non-EU member states are not. So the idea is that the white paper should create instruments to level the playing field at the international level. The other side of the coin clearly is that if you want to subject these foreign subsidies and the subsidizing action of foreign government to a unilateral action of the EU, you need to ensure an equal treatment. So the regulation of foreign subsidies should be substantially comparable and even if possible linked to the disciplines of similar measures you have in the EU, i.e. state aid measures adopted by the EU member states. This is important legally because, as many of you will probably know, one of the key principles in various iterations that you have in WTO law and trade law is the principle of non-discrimination. WTO law prohibits treatment no less favorable of foreign goods, services, service suppliers vis-a-vis domestic goods, services, or service suppliers in various legal provisions, in various treaties, like Article 3 of the GATT, Article 17 of the GATS. We might have then, footprint discussions about whether certain of these provisions might or might not apply to the white paper, but still, this is a big hypothesis, a legal hypothesis out there. The big question, legal question that we have is, will it be always possible to regulate foreign subsidies similarly to EU state aid? I have already attended quite a few webinars on this topic, and the recurrent statement of the representatives of the Commission is we will apply exactly the same rules that we apply to state aid. If that measure, that foreign subsidy, had been granted by a member state of the EU and it would have benefited from a justification, would have been considered to be compatible with EU law, well, we will do the same with this foreign subsidy. Now, the big question, and all this type of assessment goes into my understanding, into the EU interest clause, is whether this is enough, whether a formal type of equal treatment is really enough, or whether we might need to go a little bit beyond that and guarantee a substantive type of equal treatment. Why is that? Because clearly we are not talking about a subsidy granted by a member state, but a subsidy granted by another country. And it may well be that this subsidy is, for example, pursuing a public policy goal at a level of protection which is higher than the EU. What are we going to do? Higher means, for example, that the subsidy intensity which is allowed is definitely higher than what the EU stated law internally provides. What are we going to do? Are we going to say, no, I'm sorry, you are exceeding, you are out of proportion and we cannot justify you? I'm just speaking aloud, but I suppose these are the type of significant question that will come out whenever the issue of ensuring equal treatment or a similar treatment to foreign subsidy pops out. Next slide, please. The second big question from the trade law perspective is really, as I said, a constitutional question. The argument here is that WTO law may preempt EU law, or as I said, for what matters, the law of any member of the WTO, to provide for what? A specific action against a subsidy of another member. This is not my language, as you can see, is taken from Article 32, paragraph 1 of the specific agreement, WTO agreement on subsidies. And again, I read it, no specific action against a subsidy of another member can be taken except in accordance with the provisions of GATT 1994 as interpreted in this agreement. There is also a footnote there, but again, I'm not entering into these details. We have few cases, case law of the WTO, which has frankly given a quite broad interpretation of this exclusivity clause. But in any event, I can tell you that if I look at the white paper, at module 1 and even the other modules, this would become a school, a textbook example of an action which is a specific action against a subsidy. So here we would come to a scenario of paradox and irony, because if we assume that a foreign subsidy under the white paper is also a WTO subsidy under WTO law would be telling you, look, this is our stuff, this is within our jurisdiction. We are sorry that there is a gap and you cannot do anything, but you can't really, because of Article 32.1, do anything to fix the problem. We recognize there is a problem, but you cannot do anything to fix it. So that would be the paradox. But clearly, the preliminary legal issue, change slide please, is whether there is an overlap between the white paper and WTO law, and in particular, whether the definition of foreign subsidy that the Commission uses is the same definition that you find in the WTO. Because if we are talking about a different animal and we are not satisfying the WTO definition, well, then we only have to be subject to the non-discrimination principle, but we don't have to bother about subsidy rules. Now, let's see what the Commission itself says. The definition of subsidy, according to the SCM agreement, by and large coincides with the definition of a subsidy set out in the annex. And this is largely correct. Clearly, it is not the same. There are a lot of inputs coming from EU stated law, but I would subscribe to the classification of the Commission. Yes, this seems to be a subsidy under WTO law. Assuming this is correct, how do you square then any proposed instrument, including Module 1, with the prohibition of Article 32.1? So assuming that we have an overlap of definition, well, the EU got a big problem. And the white paper itself recognizes the need to respect Article 32.1. But are we talking of the same thing? Next slide, please. Maybe it is not exactly the same thing. So maybe if there is an overlap, it is only partial. Why I'm saying that? The definition of subsidy in the WTO provides for two things: a form of financial contribution and a benefit. But the subsidy must be granted within the territory, of course, of what? Of the granting government. So clearly, if you go down the second bullet point, this is taken again from the annex of the white paper, the definition of foreign subsidy. It is clear that many of the cases of foreign subsidy to which the Commission refers to refer to aid given directly to undertaking established in the EU, so outside of the territory of the granting member, or active in the EU. Yes, that is correct, but it is also an issue because they refer to cases where the subsidy is granted to undertakings that are established in a third country. So here the key question is, what is a third country? Does a third country also include the jurisdiction of the government that gives the money? And in any case, the transaction, a subsidy transaction, can be very complex there can be a very long chain with different recipients and beneficiaries. So insofar as you enter, if you have a scenario whereby at least part of the subsidy is granted within the territory, you go back to the problem before. Next slide, please. So that was about the legal issues. Now, very quickly, I will make a couple of brief comments. I know I'm basically over time already. The first comment is that leaving legal issues aside, the biggest problem of the white paper is that it tries to solve a global problem unilaterally. And you can imagine all the possible downsides on that. Is anybody going to challenge EU stated law? Just reading the public consultation, one document, the response of the Chinese Chamber of Commerce that talks about reciprocity. So probably the best level of action of this problem would be a plurilateral or a multilateral level. Clearly, the political conditions were not really there for a plurilateral or a multilateral action when the white paper was conceived, even when it was published in June. Next slide, please. But if you look at the impact assessment consultation, which was conducted in October, you start to see that among the policy option, now expressly the EU Commission is contemplating as the best route, the one that solved the problem at their source, the strengthening of international rules, either in the WTO or in future bilateral trade agreements. And final slide, please. As I mentioned, probably the political conditions have changed since the last 6 months. We should have a new administration in the US now, and this is an article taken from the FT 2 days ago. Apparently, the EU Commission has prepared a draft plan for revitalizing the transatlantic partnership, a once-in-a-generation opportunity which would cover anything. And I suppose, because I've not seen this draft plan, also the big issues of state capitalism, foreign subsidized investment, and industrial subsidies. Thank you very much for your comments.
Thank you very much, Luca. And obviously, again, message to Christophe. These are all constructive comments. So they're obviously all intended to, provide food for thoughts. But I think that, again, you've been very precise and clear in identifying some of the possible frictions and conflicts that the white paper raises with international trade. Luca has already mentioned the very important dimension of state aid law contained in the white paper, and then we can move then to the next speaker, Elisabetta. If I may add just a little extra detail about her biography. She's also a visiting professor at King's College London. One of us, we extend our, links to Brussels. Yeah. Anyway, Elisabetta, floor is yours on the, again, with particular white paper, with particular reference to, state aid control.
Thank you, Andrea. Thank you, everybody. Thank you for the invitation. As I've already had the occasion to say, this white paper brings together the two souls of my professional life, because I started my academic and professional life dealing with subsidies. I was then one of the first WTO litigators, had the luck of being on the enforcer side of the European trade policy for quite a number of years, and then always on that, with that hat, I move on to state aid enforcement. And I must say that as I've had the chance to say to Christophe a number of times, I consider this a very interesting exercise And I can recognize some of its, let's say, the sources. But I'll come to that in a minute. I think my first few slides are a bit obsolete in the sense that we have been discussing already what Module 1 covers, and both Christophe and then, Christophe has given a great account, but then Luca has picked on certain characteristics. So maybe, Chris, we can skip these. So I would stop. No, if you can go back to the previous one, I would stop just 1 second here to add a bit of color to this Module 1. It has already been said that there is a list of possible foreign subsidies likely to create distortion, and for the state aid experts in the audience, this is certainly a list that is strongly drawn from the state aid enforcement experience, apart from the first line on export financing, which is, of course, an international law concept. But then, for instance, the third bullet, subsidies to ailing undertakings. Now, this is a very typical EU state aid law concept. Subsidies or state aid to company in difficulties are considered the worst kind of subsidies. In fact, they're called the bad subsidies, if there is anything like bad and good subsidies, but and therefore they are regulated in a very strict manner at EU level, and there are a number of requirements that needs to be fulfilled in terms of own contributions by the ailing firm, in terms of restructuring plan leading to viability, and a number of other characteristics that we see then picked up here. Again, the government guarantees debts or liabilities, that's also something coming from the stated realm. In international trade, the concept of subsidy is certainly more limited. And then operating subsidies, again, considered very bad. Contrary to investment subsidies, there is a unfavorable presumption in state aid law about subsidies that help the daily operation of a firm. And so they're accepted in very exceptional circumstances. In general, when related to, we have had operating subsidies for renewable energy or technologies that are considered of European interest, but whose running is extremely expensive. Of course, there is a conjunction here of these two worlds under these concepts. As Luca was saying, is it a subsidies under WTO law or is it a state aid? There is clearly a merging of these two worlds in the type of subsidies that are covered by the paper. If we can move on to the next slide, Chris, thanks. And then indicators, size of subsidies, situation of the beneficiary, market conduct, and so on and so forth. Very much broad. I'm sure that Christophe and its team are working on refining this. We shall see what they will bring to the light, or what will come black on white. If we can go to the next slide. And this is an interesting part for me. So, as I said, given my long experience of enforcement, I place a lot of importance on the way in which the European Commission deals with procedures and actually translates into decisions the rules that it has on its book. So of this slide, I would like to put my emphasis on a couple of points. First of all, there is, again, this very state aid law, this typical state aid law concept of the EU interest. This corresponds to, the European dimension, what is called the balancing test of an aid in state aid law. And it is a test that it's very, how can I say, influenced by the times at which it is applied. So a balancing test done in these days might actually look quite different from what it was done even just 10 years ago. So it is what has allowed the Commission to basically push public spending in Europe towards its economic policy objectives or social objectives or whatever. So how will this apply in practice to analyzing subsidies that are outside the jurisdictional control of the European Union and therefore may be granted with a completely different kind of policy objective in mind? I mean, for me, it's an interesting question that remains to be seen. And then competent authority that can impose measure to redress. And I would like to draw your attention of this term competent authority because we'll come back to it in a second. If we can move to the next slide, Chris, thank you. So what are the challenges that I personally see in this exercise? And I will limit myself to module 1 so that I let the others deal with the challenges of the other modules. But in my, the first concern that this white paper raises in my eyes is the one with which Luca just closed his intervention. And it's the unilateralism that this white paper implies. So unilateralism, because if we look at the history of the European trade relations, there has been a constant shift from the multilateralism of the 90s, where the WTO was created, and we thought there would be, in the international economic order, this would be a very strong step ahead with finally a binding dispute settlement mechanism, not so usual in international law and international trade. Then we all knew the difficulties of first the Seattle Ministerial and then the Doha Round, and therefore starting with the year 2000, the Commission with then Commissioner Lamy started pushing towards regional agreements and finally bilateral agreements. And now we get to the imposition of unilateral redress measures. So in the evolution of the overall policy, for me, this is a very sad, I would say, signal, and a very serious signal that the Union is giving, because we have always been, for our very own history, at the basics multilateral. We are structurally multilateral. Second concern, as I said, through my experience of enforcer of the WTO rules, if there is one thing that I experienced firsthand was the difficulties of bringing subsidy cases at the WTO. For a simple reason, that whenever the European Union had an offensive interest, it also had a defensive interest. So we do grant a lot of state aid. Our member states grant a lot of state aid that is more and more transparent. So it's known also in the other countries. So what if all the other commercial partners that we have around the world started adopting similar measures as the one that we're thinking about? Because here the issue, I mean, is not that we approve the aids or we block exempt them, but the fact is we do grant them. And so they distort the market as much as those that are granted by other members, by other countries, and they distort the level playing field around the world. Third concern, information gathering process. Again, it's very difficult to gather information in state aid cases, very challenging. In the last and the second last revision of the state aid procedural regulation, we inserted this tool called MIT, Market Information Tool, to try and force beneficiaries, competitors to help the Commission gather that information that often the national authorities are not willing to provide. How does the Commission think that it will be able to gather this information from third countries? I mean, what kind of leverage will it have in order to gather information on these subsidies? Fourth point, which is probably the most shocking in my eyes of a European lawyer, why in an area which is partly trade and partly state aid, both of which are exclusive competence of the Union, national authorities would share the competence of reviewing or would have parallel powers to enforce Module 1. What is it that justifies such a huge shift in the approach that the European Union has always had and the European Commission has always had? So for me, a real concern. If we can move to the next slide. And the last point I want to make is the one of the rights of the alleged beneficiaries. So we shouldn't underestimate the fact that although these may be foreign companies, these are still subjects that will operate in our internal market. And if there is something that the European Union is known for, to the point of having a Charter of Fundamental Rights, is the importance of procedural rights. There is not much which has come out as yet about all of this, but this is just therefore a word of caution to Christoph and all those who are drafting. You will need to have a very solid, let's say, very solid procedural rules on these, and of course foresee the possibility of a judicial review, hopefully at the EU level, as I hope the Commission will keep this competence, but otherwise at national level. So very briefly then, as a closure comment, my fear is that this white paper, with all its very long shopping lists of very different aspects put together, from public procurement to state aid to mergers and so on, it is the result of a huge political pressure and probably what once upon a time, which has always been there, by the way. I mean, I remember epical discussions between the minister responsible for industrial policy in France and my own commissioner during those days after the great economic recession of 2008, 2012. So this kind of political pressures have always been there. What has changed is that Brexit has happened. The big member states that used to represent the liberal force is not there anymore. There is clearly a Franco-German axe which has always been pushing for this kind of industrial policy protectionism. And much to my regret, it seems that the European Commission is actually caving in and pulling together in this white paper a number of very different aspects that, from my very humble point of view, should be addressed with multilateral instruments and the existing instruments, and reinforcing our internal industrial policy rather than becoming the champions of protectionism. Thank you very much.
Thank you, Elisabetta. should I say, more constructive comments, which again provides for extra opportunity for reflection. And I think we're doing quite okay with time, but so I would probably just then move now to the analysis of Module 2, and Renato will actually take us through some of the specific points which Module 2 raises. Renato.
Thank you very much, Andrea, for your introduction, and thank you for inviting me to speak at this seminar. So, Module 2 is about the acquisition of EU targets that is somehow facilitated by a foreign subsidy, and we can move to the first slide here. So we are in a universe which is parallel to merger control, to the control of concentrations under the EU merger regulation. But let me start, since there has been, as Professor Biondi nicely puts it, lots of constructive criticism of the Commission. Let me start by agreeing very much with the Commission that EU competition law and certainly EU merger control does not address this problem. As much we can agree. Merger control is about the anti-competitive effects of mergers, but these are anti-competitive effects that result from the elimination or softening of a competitive constraint that existed before the merger and that the merger has removed or softened. It's not therefore their EU merger control to deal with the effect of subsidized acquisitions. So also the other provision that since Continental can, we know can be used in merger control to an extent, which is Article 102, the prohibition of abuses of a dominant position in the internal market, is also of very limited use when it comes to subsidized acquisitions. This could be an abuse of dominant position only in very exceptional circumstances. The acquirer must be dominant in the first place, which is not necessarily the case, of course. However, large subsidies are that benefit the acquirer. And there must be an anti-competitive effect on the market, which results from the acquisition rather than from the subsidy. So that's of not much help. And finally, the financial strength of a dominant undertaking that may well result from foreign subsidies as well as from EU subsidies, of course, is sometimes an element in an abuse assessment, but as a part of a kind of deep pocket or financial strength evaluation. But again, these are very limited sets of circumstances, very controversial, and the tool cannot really be used to fill this gap. So as long as a gap is concerned, yes, there is one if there is a problem to address. And I stress if there is a problem to address. Now, therefore, the Commission is proposing this Module 2, tackling foreign subsidies, facilitating the acquisition of EU targets. And let's have a look a little bit more in detail, and Christophe has gone through that already quickly. I want to focus on a few points a bit more in detail. And there are a couple of themes that I'm going to emphasize. The first one being legal certainty. The second being also unilateralism, protectionism, and industrial policy objectives. So let's have a look at some of these concepts a little bit more in detail in relation to the scope of Module 2. So we are talking about acquisition of EU targets. We must define acquisition. And then acquisition is defined or can be defined as direct or indirect acquisition of control. That's fine. Kind of know what it is from EU merger control. Easy. No, it's not easy, but the methodology is there, the case law is there, can be done. It can also be, of course, the acquisition of a certain percentage of voting rights or shares, So something below control, but arguably there will be a set threshold, 30%, 25%, whatever it may be. So fine, easy in a way. And then, of course, there is a test of material influence, which is below control, more than absence of material influence, and it's a very difficult concept to determine. Some jurisdictions have similar concepts in merger control or in other instruments, but this only shows to us, looking at the experience of these other jurisdictions, including the UK, that these are very complex concepts, and so as a triggering factor, I think material influence is quite problematic. It's also quite low in terms of being an identifier of potential harm. When then it comes to the target itself, again, what are the criteria that the Commission is proposing? A turnover, for example, a target that has a 100 million turnover in the EU, again, easy, fine, straightforward. We know more or less how to do it. Then they propose other factors that can be alternative. One is the value of the transaction. How much are you paying for the target? Fine, it's on the contract, but very often the price is determined at the time of closing based on a number of factors that can be only determined at the time of closing. So it has its own difficulties there. And then it gets better, because another possible criterion that is put forward is the presence of, in the EU, of assets likely to generate a significant EU turnover in the future. So this is a target without assets, but for example, which is developing an important product which may be patented, that has a significant customer base that so far does not generate turnover. So you have to look at future turnover and whether this future turnover is going to be significant. Very vague and very, I would say, gives rise to a significant degree of discretion on the part of the authority that will administer that. And then, of course, there is the financial contribution. We are not talking about subsidies here, interestingly. So you're not going to assess whether the financial contribution is a subsidy. It is enough that it is a financial contribution. Next slide, please. And the definition of financial contribution in Annex 1 of the white paper is in itself very wide. We of course recognize it as any transfer of value by a government of any public body of a non-EU state. And it can be pretty much everything. Is very much in line with the wide concept that we recognized under EU state law, state aid law. So so the first conclusion I would draw here, these triggering events themselves are very vague and undefined, and they give a lot of leeway, I think. They leave the companies in big uncertainty. And also they give lots of leeway to whoever the authority will be, and we'll come to that in a moment, to determine what transactions should be reviewed and what transactions should not be reviewed. And the net here can be cast really very wide. Because of course, I have never seen a regulator or a public authority which tries to limit its remit. So once you give a regulator wide concepts, they will become wider and wider. If you give them concepts that are narrow enough, they will be widened progressively. And if you give them wide concepts, then they will embrace the whole world before you know it. Next slide, please. So with these vague and undefined concepts to trigger the review, what is the procedure going to look like? It's going to look like, I think, very similar to EU merger control. And it will, the assumption would be, happen in parallel to merger control review. when there is an acquisition of this that also involves a foreign financial contribution. So first of all, here the preference, clearly expressed preference in the white paper, is to give the Commission the power to review this. And again, I would agree with this approach. I mean, having potentially 27 member states with 27 different procedures and triggering factors and so on, I mean, would be really a recipe for confusion and unnecessary costs. And the same, I think, would apply to Module 1. I agree with Elisabetta, but even more so to Module 2. There is going to be a mandatory filing. So a company will have, an acquirer will have to take a view on all these concepts that I was talking about before, and decide where to file and not to file. Not filing means significant fines, probably, and possibly the unwinding of the transaction as well. And there is going to be, of course, a standstill obligation, so you can close the transaction until you have it cleared. As in merger control, you can have a phase 1, clearance in phase 1, or you can have then a phase 2. The time limits here are left open. I suggest they shouldn't be really longer than in merger control, because you don't want to hold up these transactions for more than is necessary, really. And merger control is already, I think, burdensome enough in the way that it happens today in the EU. The outcomes could be unconditional clearance, conditional clearance, or prohibition. And let's move on to the next slide, please. That leads us to talk about remedies. Now, these remedies can be very wide, and they are overlapping with those in Module 1. So, of course, there could be the outright prohibition. There could be structural remedies, such as divestment of certain assets, reduction of capacity or market presence. Of course, a significant concern when it comes to subsidized acquisitions is that if these acquisitions happen in markets with excess capacity, this prevents an efficient and market-driven restructuring of the industry. They keep capacity on. They may keep one inefficient competitor oversized, so to speak, and facilitate exclusion or foreclosure of other competitors. So reduction of capacity is an obvious remedy here. There can be front obligations, so obligation to license or obligation to sell products or provide services on fair, reasonable, and non-discriminatory terms to third party. So when there is an acquisition, for example, of an essential input, of an important patent, of a bottleneck technology, so very significant remedy here. There could be publication of R&D results to allow third parties to benefit from them when, again, the subsidized acquisition concerns an EU target with significant R&D programs. Next slide, please. So, how will the Commission, because it's likely to be the Commission, there is still the option of having a shared competence with member states. How is the Commission going to then determine whether there is a problem in the first place and impose, therefore, these remedies? Well, I think we are going here really to the core of the problem, because if you read the white paper, and also as a matter of logic, I think, and economics, what is the distortive effect of a subsidy in an acquisition as such, over and above the distortive effect of a subsidy on a market which is dealt with under Module 1? the effect is, of course, as the white paper recognizes, avoiding distorting the level playing field with regard to investment opportunities in the internal market. In other words, is the market for capital and for an efficient allocation of capital, which is distorted here. Because it's not the most efficient capital that prevails, for example, in an auction for a target, but the auction is distorted by the foreign subsidy. However, when it comes to the substantive test that the Commission applies, or the authority will apply, this is a two-pronged test. First of all, the authority will need to show that an acquisition will be facilitated by a foreign subsidy. And I think that goes to the distortion of the capital market, or the market for capital. And secondly, that there is a resulting distortion of the internal market. So there is a kind of follow-on distortion in the market where the EU target competes with third parties. So that's the same with as in Module 1. That's the same with as with any state aid analysis. So there is also some kind of lack of clarity in the objective here as well. I think it's the Commission still pursuing two objectives: efficient allocation of capital and a preemptive action in relation to the same harm as would arise under Module 1. Then the Commission proposes two tests that I have called the object test and the effect test. That's the my competition distortion, I'm sure. So the object test does not look at the effect on the market of the foreign subsidy, but looks at whether the foreign subsidy directly facilitates the acquisition. And so if there is this direct link, this is a subsidy that would normally be considered to distort the internal market. Object test. So I think this is clearly linked to the market for capital distortion. A subsidy that directly facilitates the acquisition is distortive. I would agree with that, because that's distortive of the market for efficient allocation of capital. Then there is the effect test, which brings in the second element, which I think is overlapping with Module 1. These are subsidies that reinforce the financial position of the acquirer, but are not directly granted for the purposes of the acquisition. And then you look at all sorts of indicators, size of the subsidy, market situation, market position of target or acquirer, level of activity of target, whether there are other bids, and so on. And in any event, both in relation to the object test and the effect test, then you look at the EU interest test, which has already been discussed. So is there an EU interest which prevails over the harm done by the subsidy? Next slide, please. So just three final observations or questions that I would like to raise. I think the first is, assuming that this is really a good idea, and there is really, apart from a perception of harm, and clearly a political mood that in France and Germany and a number of other countries is in favor of this, fine, we accept the predominance of politics, but let's look also whether there is any evidence of actual harm going on. But if there is, then the second question we have to ask ourselves is, can the system be sufficiently clear and administrable? Because sometimes there are harms that are so difficult to address that are best left where they are, because the cure may be even more dangerous than the harm itself. So, well, I think, in order to make this white paper operational, you will need to define a lot of very vague concepts that, as I have tried to show in the little time that I had, are really very difficult to define and will not be capable of being defined with sufficient certainty. The effect test, especially if combined with the EU interest test, is really highly discretionary. Now, the definition of, whether, and the assessment of whether financial contribution then is linked, of course, if a foreign country gives an acquirer a bunch of money and say, use this money to acquire Deutsche Telekom, I mean, that's easy, right? But this will not be the cases we are going to deal with. The cases we are going to deal with is cases where acquirers have received contribution by foreign countries for all sorts of probably legitimate purposes under the legal frameworks of the countries in question, and then they acquire a target in the EU. So the assessment of the link between that subsidy and the target in the EU market, whether that money is actually used in the EU markets and so on, is going to be extremely difficult. And as Elisabetta was saying, it's already difficult enough with an EU member state that has a duty of cooperating sincerely with the European Union. Couple that with judicial review by the EU courts, which is deferential to the Commission because of the institution, nothing wrong about it. That's the institutional structure that the treaties envisage. Then really, I think we are not in the realm of a legally certain, administrable and predictable instrument, but I think we will be in the realm of geopolitical warfare, local protectionism mixed with a good dose of industrial policy. Is this bad or good? I don't know. I leave it to others to judge, but I think at least let's call things by their proper name. Next slide, please. I think this, the other question the Commission really would have to ask itself, it's really what are the costs of all of this, as well as the benefits and whether there is a gap. I think this will raise the cost of acquiring EU targets. Of course, this may discourage acquisitions. Now, if there are acquisitions that should be discouraged because of the distortive effect of a foreign subsidy, that's fine. But if these are acquisitions that should not have been discouraged because the disincentive only results from the lack of clarity and the risks that the system will bring in for acquirers of EU targets, that's not so good, especially in a moment in which the EU industry actually needs good buyers of assets that may be valuable, but they are currently in distress or looking for, crying for synergies or upgrades or upscaling in order to compete globally. So you're not so good at this moment in time, I think, having an anti-M&A policy, which this one more or less is. I mean, makes M&A more difficult. That's for sure. And so really, if this is done, at least please, let's streamline the procedure as much as possible. Let's look at options such as alternative options. For example, Christophe himself was talking about Module 1 as an alternative to Module 2. As a not an alternative. The alternative would be my proposal. He was saying, it's a safety net, so something which escapes Module 2 could still be dealt with under Module 1. Well, can we not deal with everything under Module 1 and therefore do not run the risks of discouraging efficient M&A activity, or perhaps just giving the Commission the power to call in transactions that are potentially problematic rather than introducing across the board mandatory filing. And the next slide, please, which is my last.
One minute, sorry.
Yeah, 1 minute, exactly. That's the last slide. And will this fix the problem anyway? I mean, if the problem is distortive effects on markets, you have already Module 1 if you want to implement that, and if there is really a problem. If the additional problem is the distortion of the market for efficient capital allocation in the EU, then, for example, a less intrusive alternative would be to block simply transactions that fall under the object test. Therefore, when the foreign subsidy is directly linked to the acquisition, and here the remedy would be simply a prohibition, I think, most of the times. Thank you very much.
Thank you very much. Renato, that was an extremely thorough and forensic examination. And I actually agree that some even further issues on the relationship between Module 1 and Module 2, which, I mean, there would be, probably we need to maybe add an extra session. Now, I do actually realize that we are running out of time, but, the issues are so many and so interesting that, I would simply, I don't want to punish our next speaker. So if everybody's happy to stay on a little bit longer, and if Zoom will allow us, I would simply say that, we try, maybe I'll ask again, perhaps Chris and Michael, just to be a little bit shorter, and also Alex. But again, I think that if the platform is still okay, I think we can try to carry on, and perhaps I might try just to reduce the number of questions, so on and so forth. We do actually have a double act, but I think that it's going to be well organized. So perhaps, you, Chris and Michael, go ahead. Thank you.
Michael, you're on mute.
I think you go ahead.
Thank you. Well, thank you. I think I can save time. That was a waste of time, but I can now save time because for three real reasons. Firstly, Christoph has already sort of set out the overall structure of module 3, and so I don't have to maybe set out the bare bones of it all. And secondly, module 3 perhaps is a little bit different from module 1 and 2. Module 3 is, on the one hand, to some extent, a recooking of ideas that have been around for a long time. Chris and I organized a conference in Paris, I think maybe 10 years ago, and an awful lot of the consultation responses on Module 3, frankly, were exactly the same people said exactly the same things at that conference 10 years ago. It is a lot of the same stuff again. And I think what one gets from the consultation responses is two things. Firstly, to pick up Elisabetta's point, I think there is perhaps a disappointing move away from the liberal outlook of the EU, and certainly the conventional wisdom is moving much more towards a more defensive, inward-looking economic perspective, which maybe for an old dinosaur like me is disappointing. But I think, leaving aside those philosophical issues, I think there are some just huge practical problems which will mean that Module 3 will take an awful lot longer to deliver as a practical issue. And if you learn nothing else from Chris and I's talk, you'll know the Swedish for procurement from that slide. Should we move on to 47, I think was the one I was going to jump to, Chris? We had a few slides which to some extent cover points which have already, we can go a little bit further, can't we? I think we can go on to the next one and the next one. Let's just pick up this point. I mean, it's not an old problem. The Commission has been worried. There have been parts of the Commission that have been concerned for decades that subsidized companies could make more advantageous offers, and it is partly for that reason that there have existed tools within the legislative toolbox to deal with some of these problems for a long time. They're just not used very much. Can we maybe jump on to the next one? The Commission has always conceded the sort of flip side of this, that even if it might be desirable to find a way to investigate and prevent tenders being unfairly supported by government subsidy, it's just not practical to have public buyers do this. They simply, not only do they not have the information, they don't have the practical, leaving aside the legal competence issues, which Elisabetta has referred to, which I think are also quite considerable. By and large, they simply don't have the practical competence to carry out this sort of analysis. Even within central government, most central government bodies wouldn't be able to do this, and certainly not within the sorts of timeframes that would be necessary for an efficient public purchasing process. So, you know, there's simply no hope for a local authority or executive agency to do this. Should we jump on to the next slide? But maybe one back, just to note, go to 49 maybe. Just to say, and this just to highlight, you know, these tools have existed for some time. I mean, both of these tools have been around for a couple of decades. You've been able to use to exclude bids if they are abnormally low based on state aid. There's been a question about whether that includes foreign aid, but I mean, that power has existed. They have existed within the utilities sector, a potentially powerful tool to put in place price preference for bids from third country bids outside GPA and other countries with bilateral arrangements with the EU. But they're hardly ever used, even though you'd think in the utilities sector particularly, the potential might have been significant. Shall we jump on to 52 then, Chris? I think we'll just jump ahead. There we are. The notion is therefore that if you could establish what an abnormally low tender was, and of course that remains an undefined concept in EU law, the Court of Justice after all these years has declined to step in and come up with a definitive definition where the legislator has refused to do so. Whatever that means, the notion would be that there could be some sort of exclusion, but it would have to be done. The more developed version seems to be that this would be after the purchaser has referred the matter to a supervisory authority at presumably either national or EU level to review this. But I mean, I think again, just the time frame is going to be difficult, but also issues around supply chain control. I mean, as the proposal is framed, it involves looking at every participant in the supply chain. Well, apart from anything else, it's often not clear that the supply chain is often not fully established at the time you submit the tender. And once you start getting into supply chain control, you get into all sorts of problems which have been fraught within public procurement for a long time in the context of the control of organized crime as well. So I think there are a number of practical issues there to be looked at as to what in fact can be achieved. And what can be achieved without completely undermining the effectiveness of an efficient public procurement system. Shall we jump ahead to 53? The response to the consultation produced a lot of responses from member states who most of whom seem to have agreed that there's a problem, but they've agreed there's a problem for 20 years. They favor legislative measures. Well, there's been draft legislative measures around in different formats since 2012, and then again in 2016. There is an issue about linking up the potential procurement instrument with this, and I think that it would make no sense to go ahead without having a coherent external procurement policy. But having expressed all their positivity, the practical points that are raised by member states and then by other consultees seem to me to be really quite fraught, and I've already identified a couple of them. Around the basis of administration, the criteria, the process, simply the process of deciding how you are going to refer. There is, as I say, using abnormally low tenders as a definitional concept is a challenging starting point when there is no settled definition of the concept. And the reality is that the concept of abnormally low tenders has been a tool, as much a tool for abuse of the system as it has been a useful tool in the system. Both contracting authorities and aggressive disappointed tenderers have made aggressive use of the abnormally low tender in quite improper ways over the last 25 years. And to give them another opportunity to use that tool is, well, it's just going to give give people another opportunity to find opportunistic means of undermining efficient procurement. So in the spirit of constructivity, or whatever that word should be, I think I would say that yes, it's a problem. It's always been recognized as a problem. But I don't think module 3 is much of a better answer than any of the answers there have been for the last 20 odd years. I think if this is going to work, there has to be a clearer, more multilateral approach to this. But then perhaps, given the prejudices I've already ventilated, he would say that, wouldn't he? Chris, perhaps you can give a more sensible and measured view about what this should be said.
Thank you very much. Can you hear me okay, Michael?
Yes, I can hear you.
So I want to offer a few observations from across the pond, and I'm going to be brutally frank about American politics, and I'm going to be very polite about European politics because, of course, I'm an American, and I'm not experiencing it firsthand. But I can tell you what's going on here. So to understand the American political situation, in some ways, it's interesting. There are observers who argue that we're moving backwards through European history here. That over the summertime, the violence that you saw here in the United States in the mass media, that violence represents what would have been the brown shirt phase in the 1930s in Europe, in various parts of Europe. And then now after the election, we're going to go through a very tumultuous phase, which has been analogized to the Treaty of Versailles, a pivotal moment in our history, which is being used by certain parties to create further divisions in our society. In that light, in a big picture here, I think it's fair to say that as of right now, Donald Trump is probably running against Kamala Harris in 2024. That's the structure. It's very unlikely that Joe Biden will continue into a second term because of his age. I'm actually, ironically, I'm just a few kilometers from his summer home here in Rehoboth Beach. He's said privately early in the campaign that he'd only serve for one term, and that's very likely. So everything the Biden administration will do has to be geared towards Kamala Harris facing off against Donald Trump in 2024. In that light, it doesn't make sense from an American perspective to have trade friction with the European Union because the Biden administration, while it's difficult to anticipate what they'll do at a base level, political level, it is easy to predict what they'll do on an international level, which is to be a responsible adult, be opening up doors, opening up pathways for cooperation with our international partners. So one danger of the white paper is creating trade friction at exactly the wrong time, creating trade friction with the United States and other trading partners at exactly the wrong time. The second issue is derailing the EU procurement regulation. What's happened with the EU procurement regulation over the last decades, and we've watched it from across the pond, is that more and more the European Commission, the European Union has become a voice of good governance in procurement in a very important way. The white paper takes everything in a different direction. No longer is there a focus on good governance and procurement, but instead focusing on market issues. And that, in some ways, from an American perspective, that raises the risk of delegitimizing the procurement regulation in the European Union. It also has, as Michael's pointed out, has a risk of disrupting member state procurements in a very practical way. Now, Michael was very gentle about this, but as a practical matter, it's very possible that competitors will use the white paper and use the remedies on the white paper to try to upend competition, which would be disastrous for the member states. There is a possible way forward, at least with the United States, a way to deal with this issue, but without these dangers. One is to use the process that Luca referred to in his presentation, what I would refer to as TTIP2, a revival of the Transatlantic Trade and Investment Partnership, and to include abnormally low tenders in the regulatory cooperation that would likely come through a TTIP process. To address abnormally low tenders, which frankly haven't been dealt with well in the U.S. law, but dealt with more effectively in the European Union, deal with them as an area of regulatory discussion, regulatory cooperation. An important point here, the second bullet point, the European Union, unlike the United States, treats commercial markets as part of its responsibilities. For 200 years in my country, in the United States, the federal government has dealt with the commercial markets as a source of exploitation. They want to take advantage of commercial markets, but they really don't see a governance responsibility to make sure that public procurement is integrated with those markets. The $500 billion federal procurement budget is about the size of Michigan. We would never, ever think of isolating the state of Michigan and its economy from the rest of the US economy, but that's really what we do in federal procurement. The folks who run the federal procurement system don't care about integration with the broader commercial market, but in Europe you do, and that's a point worth making in discussions with the United States. The last is to coordinate on the grounds and procedures for exclusion based on abnormally low tenders, if in fact those, for example, those abnormally low tenders pose performance risk or pose issues of market disruption, as the white paper points out. The exclusion process, the debarment process under the EU directives, for example, Article 57 of the 2014 main directive 2014/24/EU. Article 57 just brings the European Union around the corner to begin discussing a debarment process, which is already well advanced in the United States and elsewhere around the world. It's important to be able to work out common procedures for debarment and importantly, work out ways to share information on contractor qualification where specific contractors pose risks. So this is actually an opportunity to enhance cooperation and not necessarily to lead to acrimony and fighting at a very sensitive time in the European Union's history and the United States history. Thank you.
Thank you, Chris, and thank you, Michael. Again, all in the spirit of, I was thinking, is it constructivity or constructiveness? I'm not sure which one is the proper one, but
it's constructiveness. It's constructiveness, but anyway, I thought I'd coin a new word.
It's very difficult words to pronounce for no mother tongue anyway. But again, thank you very much. And again, we've just now widen up a little bit the perspective to third countries. And well, we thought about finishing with a light note and discuss a little bit what are the possible implications of whatever will come out of from the white paper on the UK and in particular, on everything that is going on at the moment in this country. And we're very fortunate to have Alex, which will lead us through an extremely easygoing, piece of cake topic. Alexander.
Yeah, absolutely. A bit of a thorny subject, but naturally one that's changing by the minute. So first and foremost, thank you ever so much for inviting me today. As you can see from these slides, I'm going to be discussing the impact of the white paper on UK-EU negotiations. Now, in doing so, I'm going to focus almost entirely on one module. That's the Commission's core goal of addressing the impact of the distortive effects of foreign subsidies by essentially imposing EU state aid law through Module 1. Now, the reason that I'm going to focus so much on that is that at the moment, there is no agreed trade agreement between the UK and the EU. But what we do know is that the talks are currently stalled, and they're stalled on 3 points. Those 3 points are fishing policy, the governance and the ratcheting clauses in the way that both the EU and the UK will essentially exist in parallel in the future. And then the third one, the key one, is state aid control. Now, at first glance, the introduction of this white paper during the negotiations appears to be a negotiating tactic on the part of the EU to say, even if you walk away from the table now, you will still be subject to similar rules. However, I don't believe that was the intention of the EU, and I don't think it had that outcome. And that's what I'm planning to explain now. But before I get there, if you'll permit me, I'm going to go and set the scene and explain the developments that have occurred since that summer's day in 2016, when the UK electorate voted to leave the European Union by 51.9% to 48.1%. Now, legally, the process to leave starts by the issuing of notice under Article 50 on the 29th of March. You then have what is essentially a divorce process So you have the UK entering into discussions about how it will extricate itself. And that includes things, quite detailed discussions around financial repayments, what will exist with common institutions that have been set up. And that eventually culminates on the 17th of October 2019 with the withdrawal agreement. Now, the withdrawal agreement does three things. First and foremost, it formally ends the UK's membership at 11 p.m. on the 31st of January 2020. Secondly, nothing changes in the immediate. What happens is you enter an 11-month transitional period, and that transitional period ends 11 p.m. on the 31st December 2020. And then thirdly, it sets out a political declaration. So this is essentially the basis, the heads of terms for that future relationship between the UK and the EU. And in terms of state aid, it's quite light on the ground, but what it does say is that they agree they'll maintain the same high standards. So trade talks begin in March this year, and initially they make progress pretty quickly. The problem is that in the summer, after about 3 months of talks, suddenly they become gridlocked. And they become gridlocked on those three issues that I've just mentioned. Now, state aid isn't resolved quickly, but when the white paper's developed, the issues with the UK wouldn't have been at the forefront of the Commission's mind. And there's two main reasons for that. The first is that we're dealing with the impact of essentially subsidies coming through often state-owned enterprises. And the focus isn't the UK in this respect, it's China and some other countries. So for example, in 2020, for the first time ever, China has more Fortune 500 companies than any other country. It has 124. And of those, from a little bit of research, it appears about 71 are state-owned enterprises. The second reason is the UK isn't a country that has state-owned enterprises or many state-owned enterprises, and it certainly doesn't award many excessive subsidies. And you can see that from its compliance with the EU state aid law. Indeed, prior to issuing notice to leave, the UK was one of the loudest voices for strong subsidy regulation. And you can see in terms of the levels of state aid awarded, one of the reasons why. So if you go to the 2017 figures, the UK state aid amounts to about 0.35% of GDP, so not much. In Germany, it's 1.31%, so 3.5 to 4 times as high. Also, in the 21 years, and this is a quote Boris Johnson's speech, in the 21 years leading up to 2020, the UK was found in breach of state aid rules 4 times, compared to France 29 times and Germany 67 times. So the UK has a good reputation in this area. Now, so the Commission was essentially drafting the white paper because it felt there's a threat to the market. And secondly, it feels the WTO doesn't provide a meaningful means to address these problems. Now, in terms of the UK position, if we go on to the next slide, please. In terms of the UK position, the UK position in the state aid, in the trade talks, on the surface, it appears to have quite similar aims to the EU, which is both benefit from having a robust and meaningful regime. But if you start to drill down, you can, sorry, can we just jump onto the next slide, please? If you start to drill down, you can start to see in some of the quotes why it became a difficult problem and one that still isn't quite yet resolved. So the first quote is from Boris Johnson in his Greenwich speech. Now, what he's saying there is they'll have subsidy rules, but they won't be the EU ones. That's what he means by full sovereign control. If you go to the Liz Truss quote, what Liz Truss, the UK International Trade Secretary, is saying is that she sees the UK as a thought leader within the WTO addressing issues such as industrial subsidies and state-owned enterprises. And then finally, this point that Michael Gove's quote here, so Michael Gove is the is the minister who's actually in charge of making preparations for Brexit. The subsidy regime the UK proposes to put in place after we've left the EU will be one the EU will recognise as a robust system. The key words there are put in place after we've left the EU. Now, we may have heard that at the time and thought, oh, actually, what they're planning here is they're planning to have a system ready to go from day one. But actually, in terms of the mentality here, I think what the UK's ideal position within the trade agreement would be is paper thin. So that is essentially an ex-post regime, so ask for forgiveness later, based on a set of very broad principles. It doesn't want a regulator. It doesn't want tightly defined rules. In contrast, the EU is pushing for a similar alignment, as close alignment as possible. So looking for detailed ex-ante regime with a regulator. And at the point when the trade talks aren't making the progress everyone wants, the white paper comes out. Now, what the white paper does is make the EU negotiation position more difficult. So it floats the idea of an ex-post regime, which gives credence to the UK's argument that that's what should go into the treaty. The UK wants lighter rules that only bite when there's a real distortion, as opposed to the EU regime. So at one point, the Commission had argued for the EU state aid rules to apply in the UK, and they have one of the characteristics of state aid is that there has to be an effect on trade between member states, and that effect on trade is incredibly easy to meet, to the point that in some cases it's been found where a potential entrance to the market may have been put off. Not a real entrance to the market, potential. So when you're doing the assessment, you have to take into account this potential phantom entrance to the market. But what this is doing is, what this regime is saying is that actually you could have rules that genuinely do bite when there's a real distortion. The third part is that the Commission have quite rightly argued that they have the gold standard of subsidy control rules. But what this paper shows is that actually a lot of the Commission staff, I think, would actually change it if they could. If they had the chance to rewrite the rules again, they would make some changes. So, for example, in the event that you award unlawful state aid as an EU member state, the sanction is that you have to recover the funding from the recipient with compound interest. So the money comes back into the state's coffers. Whereas what's being proposed in the white paper is that actually doesn't go back to the state that provided that subsidy. It actually goes to the EU or the country that within the state affected. So what that says to the negotiating team is, well, actually, even the Commission would like to change their own test, whereas the UK is about to write its own. It also clearly is a challenge to the WTO approach, in that it's essentially saying we're going to address this separately without going through the WTO process. And then finally, there's references to supervisory bodies within the states. Now, if the UK has been arguing that they don't want a regulator, but they're mulling over whether to trade that for a different compromise, what this does is it adds value to that trade, because you know that the EU is desperate for that to be in place in order for this to work properly. So overall, for those 5 reasons, I think the white paper has made the negotiators' job harder. But that said, I don't think that it's going to get in the way of a deal. I think a deal will be done, and I think a deal will be done because of the reasons I've already set out, which is subsidy control is ultimately in the UK's mindset. Therefore, it is not a basis to lose a deal on. So to conclude, I think the white paper wasn't designed to catch the UK, but I think it has had an effect on the negotiations, but it's not going to derail them. Thank you.
Thank you very much. We will see in the next 30 days or so. Now we are now officially late, but I hope that we can still scrap a few extra minutes. I think that what I will do is perhaps to try to go through some of the questions very quickly, and then we just, if Christoph can still bear with us, give Christoph the floor for a very brief final conclusion. Now, I think that we got a couple of questions, which I think that again they can probably be answered by different speakers, but and I think that the first one that I have is from Harriet Brown, that she's actually asking about the relationship between Module 1 and Module 2, in particular whether an acquisition that have been reviewed and approved under Module 2 can then be later be subject to an investigation under Module 1. Perhaps I would actually link it to also a very specific point raised on the question of, I think that this is a little bit more on the public procurement point, is whether, again, how easy it's going to be to establish a causation or a link between a subsidy and a perceived advantage to EU tender process. That is a question from Italia Carson. Should we start with these two, and then I will simply collect the others? I don't know if anyone wants to tackle these first couple of points.
Shall I jump
Yes,
in on the okay? Which
no,
one's
please,
first?
Michael. If
I'll do the public procurement one. Shall I? As it's, I think, low hanging
Yes.
fruit. I totally agree. I mean, I think it's a real problem because insofar as there is a defined legal concept of abnormally low tenders, as Chris Hukins referred to, it is something to do with the non-viability of the tender. Almost by definition, no one's suggesting that the tender is not viable if it benefits from state aid. It's rather too viable. That's its problem. And so you've got to find a different definition to try and work out, what is it? Are you going to say that if the state aid is somehow causative of that of the tenderer winning the contract? Well, how are you going to work that out? If particularly as most state aid will probably be indirect, and you might be dealing with export credit insurance at a preferential rate or whatever it is. How can you possibly undertake the causation analysis? I think in the end you will end up in order to make these sorts of systems work, you end up with some sort of crude tool, like having a built-in price preference. If it has been established that X company benefits from state aid exceeding in value over euro 10 million, then they will have to beat a price advantage of 1% in the final bid. I mean, no idea if those numbers make sense, but you'll end up having to have some very crude test, because anything else will take months, or if not years, to work out.
Yeah, Andrea, maybe I can take the question on
the relationship, perhaps.
So, well, if that depends on the distortion that is alleged to be to occur under Module 1, I think, because the principle is that it goes back to basic principles of EU law and the effect of a decision by the Commission. And so let's assume it's the Commission here that makes the decision, because that's low-hanging fruit. It's an easier answer to the question. So if the Commission clears an acquisition, and it says that it's not distortive, or the EU interest test is met, then it is no longer possible to challenge the situation that the Commission has taken into account in its decision. So, for example, a member state, whether it be a court or a national authority, cannot take a decision running counter the decision of the Commission. But then the issue is there a distortive effect of a subsidy that goes beyond what the Commission considered. Because, for example, there are ongoing subsidies, or a subsidy that the Commission has not considered in the review of the acquisition. And then that would be open, I think, to a potential Module 1 challenge as well.
Thank you. I would probably now, there's one specific question for Luca, and then there are 2 or 3 general points which we can probably just take together. And it's a question from Ms. Rasogi. Whether you, Luca, have a sort of, what's your take on transboundary subsidies with reference to the, to the WTO agreement? That's a bit of a slightly challenging question, I would say.
I will be very short here because clearly we don't have time. I don't think they are covered. That's it.
Exactly, it's a hard one, yeah. That's it, yeah. Okay. That was a straight answer. Now, I think that, again, and I would also like to invite, if there are any other comments from panelists, they're very welcome. Then I have, should we say, 2 or 3 general points which are probably more directly linked to Christophe's presentation. Now, the first one is whether from Dr. Kritsialis, actually, where, how are you actually going to get the information, and I'm using his words, from rather opaque regimes? How this is going to work for the Commission. Then another general question from Beaumais is whether in reality, as we are dealing here, the white papers keep on pushing this idea of equal level playing field concerning state aid. In reality, whether somehow, if the white paper is going to result in some kind of legislation or some hard law, whether there will be some kind of beneficial influence on exactly how we're going to develop the notion of state aid in EU law. Certain kind of concepts which are obviously now still quite difficult to grasp might actually benefit from a sort of interaction with the new concept of state aid developed by the white paper. And finally, let me see, because I lost my track. I think I might be done, actually. I hope that I cover all the questions. So perhaps I might simply, if there are no other observations, either from the other panelists or from the audience, I might just simply leave the floor to Christophe for some sort of reply to those questions, and perhaps a little bit of wrapping up. And again, I would like to thank you for your patience. It's been a very intense seminar, but the floor is yours for a sort of a quick wrap up.
No, yeah, there's a lot to be said, but seeing the time, of course, I will try to be short and just not take very much time, and just pick up on some points, and maybe to start with the 2 questions you raised that's come from the audience, and on the question of gathering information. And obviously that will be difficult. I think we are under no illusion that it's difficult to get information, especially as it comes from countries outside the EU. But this being said, I think that it's not an unusual situation, because when you think about trade policy instruments and trade defense instruments as well, if you have to track down a subsidy in a third country, it's a similar situation from which we can learn. And if you think about it, it's always a foreign subsidy that is assumed to have an impact in the EU. So most of the time there may be a subsidiary of a company in the EU, or some establishment of a company that receives a foreign subsidy in the EU, which is basically also the hook to get the information. So I think that should make it not too difficult, and even, it will be difficult, but should make it easier, let's say. And even I think we would proceed also like is done under trade policy if we could come to a conclusion based on the facts available, in view of the difficulties to get the information. when it comes to the second question on, well, will there be a way back also an influence on EU state aid rules? I think this is not the idea. I think the idea at the moment is really to use as much the procedures and concepts that are used in EU state aid and apply them in a manageable way to foreign subsidies. And the idea is not now to change then the EU state aid rules. Who knows, maybe in 10 years, if we come up with better procedures and concepts for foreign subsidies, that may then feed back into what's happening under EU state aid rules. But that is obviously not the attention at this stage. If I may pick up just on a few points, and thanks to all the speakers before me, and I think there's really there are lots of interesting points and relevant points that you've raised, and there's been a lot of constructive criticism. If I may reply to, is there an overlap between the WTO rules now and this foreign subsidies instrument? I think the simple answer, it's what I tried to hint at also in my presentation, is the SCM agreement. So even if we use the same definition, or it's not exactly the same, I think as Luca found out exactly, it's not the same, because we're talking about subsidy given in one country that has an effect in another country, which is the difference to the definition of subsidy in the under the WTO rules. But even though it's it's almost the same, but the SCM agreement applies only to goods, not trade in goods. And that's something that we are likely to carve out from that instrument, precisely to avoid this overlap and conflicting rules. But that leads me to a more general point, and I think this should be seen as a defensive instrument. That means to the extent that there are rules at international level under the WTO or multilateral or bilateral level, we say explicitly in the white paper that these rules should prevail. And it's only if there is indeed a gap, or if the international rules or bilateral rules do not deliver. And I think the white paper even mentions, if, for example, there's a bilateral agreement that includes rules on subsidies, but after a year, there is still no progress on this, that this defensive instrument of the foreign subsidy control could be triggered. So, and that's also leads me to a point, I think, basically Betta and Renato, I think, were quite vocal about this. Is this a new area of protectionism? I honestly don't think so, because we see, well, because there is no progress at the moment at international level under the WTO, it's this, well, defensive instrument that is necessary, as, I mean, we think there are these foreign subsidies influencing the market. But maybe this instrument, I think, in the best case scenario, can trigger and incentivize negotiations or progress on the negotiations at international level about subsidies. If in the end this foreign subsidies regulation is not necessary because rules are found at international level, I think for me is the best outcome we can imagine. So and maybe this will help to stimulate the discussions at international level again. And as I said, if there are rules in place at international level, they have prevalence, just because international rules have prevalence over what the EU would do unilaterally. Then, yeah, maybe also one comment on Renato, and I think you absolutely rightly say the concepts under Module 2, but the same can probably be said about Module 1 as well. Concepts are not clear. Absolutely, it's true, because, well, I think also we should mention and stress we are talking here about a white paper so that has launched a number of ideas, and obviously if this becomes law, the concepts will have to be specified. It will be difficult. I think, Renato, you pointed out absolutely there are some it's not just about defining a certain threshold. There are certain concepts that will be difficult to define, and you, I think, rightly gave the idea of EU interest test, and I think we certainly have an interest to define this in a specific way to give legal certainty and to avoid, as you say, a geopolitical warfare. I certainly think this is not the intention with this instrument. And maybe a final comment on the UK negotiations with the UK. I think I agree with Alexander to the point that this is not the instrument was not designed with a view to the Brexit. I think it really predates. Well, it doesn't predate it because Brexit has been going on for such a long time. The considerations, but I think it really has a much larger angle. But I think there is a specific situation, and I think I have to say I was a bit amused by your comment to say that this white paper shows that we in the EU would actually like to rewrite our state aid rules, and what is in the white paper should be the true state aid rules. I don't agree, but because and there's still I think the EU position in the negotiation on the Brexit are still to, as you rightly said, to echo and mirror as closely as possible EU state aid rules, because here with the UK the idea is to be in a different relationship in the future with the trade agreement to be negotiated than with other third countries, because the idea is the UK should be part of the customs union, so there should be an as close economic integration with the UK as possible. But that, of course, makes it, well, from the EU's point of view, necessary to align the rules as much as possible. And there have been also statements by I think Boris Johnson or other members of the government who hinted at the fact that the UK actually could, once out of the EU, benefit from very advantageous tax measures, to incentivize business to invest in the UK. So I mean, that's very much my personal opinion, obviously, but just to assume the UK wouldn't use state aid, which is a very large concept, to attract business at the doorstep of the EU in the future it may be true, but it may not be true. And I think that's how the EU has to be understood in the negotiations, rather be sure than sorry. So I think this is a particular situation, a particular negotiation between the EU and the UK that I don't think can be compared to the scope of this foreign subsidies instrument more generally. I'll leave it at here, not to prolong the discussion much more. Voila, but thanks very much for all your comments and presentations. Very much appreciated.
I think we can all agree that tonight's word is constructiveness, right? And I think in that spirit, perhaps I would propose to all our speakers to reconvene, a few months down the line to see exactly how things will shape up. I think will be, it's an issue that clearly needs to be revisited, and I think that, as Christophe rightly reminds us, we like, saying everything, but it is a white paper. So I think that that's exactly the spirit of this kind of initiatives, that of soliciting ideas, comments, and even criticism. I think that, as I said, we are running out a little bit of time, but before I just leave the very final word to Chris, I think that on behalf of the Center of European Law, and I think that, if I may, probably also on behalf of our audience, thank you so much. It's been a fascinating afternoon. All presentations were extremely good, exhaustive, and thanks so much, really, because all the speakers have really made an effort to engage with the topic. So thank you, really, once again. And now I just simply just leave for the very final points, the floor to Chris. Chris.
Thank you very much, and thank you all for a very, very successful webinar. It's been I've learned a tremendous amount, and I know our audience members have as well. As I said before, this recording will be posted on YouTube later this afternoon. It takes several hours to process. You'll be able to access it through Public Procurement International. Our next webinar will be on December 10th. It will be discussing the delivery of the vaccine, both in the United States and, importantly, internationally. I very much look forward to everyone joining us then. Thank you. Have a good evening.
Thank you. Goodbye.
Thank you. Bye.
Bye-bye.
Thank you very much.
Thanks a lot. Bye-bye.
Bye. Thank you.
Bye-bye.